Civil Code of the Philippines, Book 1, Persons. Title 1, Civil Personality, Chapter 1, General Provisions. Article 37. Juridical capacity, which is the fitness to be the subject of legal relations, is inherent in every natural person and is lost only through death. Capacity to act, which is the power to do acts with the legal effect, is acquired and may be lost. Article 38. Minority, insanity, or imbecility, the state of being a deaf-mute, prodigality, and civil interdiction are mere restriction on capacity to act, and do not exempt the incapacitated person from certain obligations as when the latter arise from his acts or from property relations such as easement. Article 39. The following circumstances, among others, modify or limit capacity to act: age, insanity, imbecility or state of being a deaf-mute, penalty or prodigality, family relations, alienage, absence, insolvency, and trusteeship. The consequences of these circumstances are governed in this code. Other codes, the rules of court, and in special laws. Capacity to act is not limited on account of religious belief or political opinion. A married woman, 21 years of age or over, is qualified for all acts of civil life, except in cases specified by law. Natural persons. Chapter 2, Natural Persons. Article 40. It was superseded by Article 5 of PD number 603, the Child and Youth Welfare Code, which states commencement of civil personality. The civil personality of the child shall be commenced from the time of his conception, for all purposes favorable to him, subject to the requirement of Article 41 of the Civil Code. Article 41. For the civil purposes, the fetus is considered born if it is alive at the time it is completely delivered from the mother's womb. However, if the fetus had an intrauterine life or less than 7 months, it is not deemed born if it dies within 24 hours after its complete delivery from the maternal womb. Article 42. Civil personality is extinguished by death. The effect of death upon the right and obligations of the deceased is determined by law, by contract, or by will. Article 43. If there is a doubt as between two or more persons who are called to succeed each other as to which of them died first, whoever alleged the death of the prior to the other shall prove the same. In the absence of proof, it is presumed that they died at the same time, and there shall be no transmission of rights from one to another. Chapter 3, Juridical Persons. Article 44. The following are juridical persons. 1. The state and its political subdivisions. 2. Other corporations, institutions, and entities for public interest or purpose created by law. Their personality begins as soon as they have been constituted according to law. 3. Corporations, partnerships, and associations for private interests or purpose to which the law grants the juridical personality, separate and distinct from that each shareholder, partner, or member. Article 45. Juridical persons mentioned in number 1 and 2 of the preceding article are governed by the laws creating or recognizing them. Private corporations are regulated by the laws of the general applications of this subject. Partnership and associations for private interest or purpose are governed by the provisions of this code concerning partnership. Article 46. Juridical persons may acquire and possess property of all kinds, as well as incur obligations and bring civil or criminal actions in conformity with the laws and regulations of their organization. Article 47. Upon the dissolution of corporation, institution, and other entities for public interest or purpose mentioned in number 2 of Article 44, their property and other assets shall be disposed of in pursuance of law or the charter creating them. If nothing has been specified on this point, the property and other assets shall be applied to similar purposes for the benefit of the region, province, city, or municipality, which during the existence of the institution derive the principal benefits from the same. Title 2, Citizenship and Domicile. Article 48. The following are citizens of the Philippines: those who are citizens of the Philippines at the time the adoption of this Constitution. 2. Those whose fathers or mothers are citizens of the Philippines. 3. Those born before January 17, 1973 of Filipino mothers who elect Philippine citizenship upon reaching the age of majority. And 4. Those who are naturalized in accordance with law. Article 49. Naturalization. Naturalization and the laws and the reacquisition of citizenship of the Philippines are governed by special laws. Article 50. For the exercise of civil rights and the fulfillment of civil actions, of civil obligations, the domicile of natural persons is the place of their habitual residence. Article 51. The law creating or recognizing them or any other provision does not fix the domicile of the juridical person. The same shall be understood to be the place where their legal representation is established or where they exercise their principal functions. Title 10, Funerals. Article 305, the duty and the right to make arrangement for the funeral of a relative shall be in accordance with the order established for support under Article 294. In case of descendant of the same degree or of brothers and sisters, the oldest shall be preferred. In case of ascendants, the paternal shall have a better right. Article 306. Every funeral shall be in keeping with the social position of the deceased. Article 307. The funeral shall be in accordance with the express wishes of the deceased. In the absence of such expression, his religious belief or affiliation shall determine the funeral rites. In case of doubt, the form of the funeral shall be decided upon the person obliged to make arrangement for the same, after consulting the other members of the family. Article 308. No human remains shall be retained, interred, disposed of, or exhumed without the consent of the persons mentioned in Article 294 and 305. Article 309. Any person who shows disrespect to the dead, who wrongfully interferes with the funeral, shall be liable to the family of the deceased for damages, material and moral. Article 310. The construction of a tombstone or mausoleum shall be deemed a part of the funeral expense and shall be chargeable to the conjugal partnership property if the deceased is one of the spouses. Title 12, Care and Education of Children. Article 356, every child, 1. Is entitled to parental care. 2. Shall receive at least elementary education. 3. Shall be given moral and civic training by the parent or guardian. 4. Has a right to live in an atmosphere conducive to his physical, moral, and intellectual development. Article 357, every child shall 1. Obey and honor his parents or guardian. 2. Respect his grandparents, old relatives, and persons holding substitute parental authority. 3. Exert his utmost for his education and training. 4. Cooperate with family in all matters that make for the good of the same. Article 358, every parent and every person holding substitute parental authority shall see to it that the rights of the child are respected and his duties complied with, and shall particularly by present an example, imbue the child with high-mindedness, love of country, veneration for the national heroes, fidelity to democracy as a way of life, and attachment to the ideal of permanent world peace. Article 359. The government promotes the full growth of the faculties of every child. For this purpose, the government will establish, whenever possible, 1. Schools in every barrio, municipality, or city where optional religious instruction shall be taught as part of the curriculum at the option of the parent or guardian. 2. Puriculture and similar centers. 3. Councils for the protection of children. And 4. Juvenile courts. Article 360. The Council for the Protection of Children shall look after the welfare of the children in the municipality. It shall, among other functions, 1. Foster the education of every child in the municipality. 2. Encourage the cultivation of the duties of parents. 3. Protect and assist abandoned or mistreated children and orphans. 4. Take steps to prevent juvenile delinquency. 5. Adopt measures for the health of children. 6. Promote the opening and maintenance of playgrounds. 7. Coordinate the activities of organizations devoted to the welfare of children and secure their cooperation. Article 361. Juvenile courts will be established as far as practicable in every chartered city or large municipality. Article 362. Whenever a child is found delinquent by any court, the father, mother, or guardian may, in a proper case, be judicially admonished. Article 363. In all questions on the care, custody, education, and property of children, the latter's welfare shall be paramount. No mother shall be separated from her child under 7 years of age unless the court finds compelling reason for such measure. Article 13. Use of surnames. Article 364. Legitimate and legitimated children shall principally use the surname of the father. Article 365. An adopted child shall bear the surname of the adopter. Article 366. A natural child acknowledged by both parents shall principally use the surname of the father. If recognized by only one of the parents, a natural child shall employ the surname of the recognizing parent. Article 367. Natural children by legal fiction shall principally employ the surname of the father. Article 368. Illegitimate children, referred to in the Article 387, shall bear the surname of the mother. Article 369. Children conceived before the decree annulling avoidable marriage shall principally use the surname of the father. Article 370. A married woman may use 1. Her maiden surname and add her husband's surname, or 2. Her maiden first name and her husband's surname. 3. Her husband's full name but prefixing a word indicating that she is his wife, such as Mrs. Article 371. In case of annulment of marriage and the wife is the guilty party, she shall resume her maiden name and surname. If she is the innocent spouse, she may resume her maiden name and surname. However, she may choose to continue employing her former husband's surname unless the court decrees otherwise, or the former husband is married again to other person. Article 372. When legal separation has been granted, the wife shall continue using her name and surname. The wife shall continue using her name and surname employed before the legal separation. Article 373. A widow may use the deceased husband's surname as though he were still living, in accordance with Article 370. Article 374. In case of identity of names and surnames, the younger person shall be obliged to use additional name or surname as will avoid confusion. Article 375. In case of identity of names and surnames between ascendants and descendants, the word junior can be used only to a son. Grandsons and other direct male ascendants shall either add a middle name or the mother's surname, or add the Roman numerals 2, 3rd, and so on. Article 376. No person can change his name or surname without juridical authority. It is repealed by RA number 9048. Article 377. Usurpation of a name and surname may be the subject of an action for damages and other relief. Article 378. The unauthorized or unlawful use of other person's surname gives a right of action to the latter. Article 379. The employment of pen names or stage name is permitted, provided it is done in good faith and there is no injury to third person. Pen names and stage names cannot be usurped. Article 380. Except as provided in the preceding article, no person shall use different names and surnames. Title 14, Absence. Chapter 1. Provisional measures in case of absence. When a person disappears from his domicile, his whereabouts being unknown, and without leaving an agent to administer his property, the judge, at the instance of an interested party, a relative, or a friend, may appoint a person to represent him in all that may be necessary. This same rule shall be observed when, under similar circumstances, the power conferred by absence has expired. Article 382. The appointment referred 2 in the preceding article having been made, the judge shall take the necessary measures to safeguard the rights and interests of the absentee and shall specify the powers, obligation, and remuneration of his representative, regulating them according to the circumstances by the rules concerning guardians. Article 383. In the appointment of a representative, the spouse present shall be preferred when there is no legal separation. In the absence left, if the absentee left no spouse, or if the spouse present is a minor, the competent person may be appointed by the court. Chapter 2, Declaration of Absence. Article 384. 2 years having elapsed without any news about the absentee or since the receipt of the last news, and 5 years in case the absence has left a person in charge of the administration of his property, his absence may be declared. Article 385. The following may ask for the declaration of absence. 1. The spouse present. 2. The heirs instituted in a will who may present an authentic copy of the same. 3. The relatives who may succeed by the law of intestacy. 4. Those who may have over the property of the absentee some right subordinated to the condition of his death. Article 386. The judicial declaration of absence shall not take effect until 6 months after its publication in a newspaper of general circulation. Chapter 3. Administration of the property of the absentee. Article 387. An administrator of the absentee's property shall be appointed in accordance with Article 383. Article 388. The wife who is appointed as an administratrix of the husband's property cannot alienate or encumber the husband's property or that of the conjugal partnership without judicial authority. Article 389. The administration shall cease in any of the following cases. 1. When the absence appears personally or by means of an agent. 2. When the death of the absentee is proved and his testate or intestate heirs appears. 3. When a third person appears, showing by a proper document that he has acquired the absentee's property by purchase or other title. In these cases, the administrator shall cease in the performance of his duties, of his office, and the property shall be at the disposal of those who may have a right thereto. Chapter 4. Presumption of Death. 392. Article 390. After an absence of 7 years, it being unknown whether or not the absentee still lives, he shall be presumed dead for all purposes, except for those of succession. The absentee shall not be presumed dead for the purpose of opening his succession till after an absence of 10 years. If he disappeared after the age of 75 years, an absence of 5 years shall be sufficient in order that his succession may be opened. Article 391. The following shall be presumed dead for all purposes, including the division of the estate among the heirs. 1. A person on board a vessel lost during a sea voyage, or an aeroplane which is missing, who has not been heard for 4 years since the loss of the vessel or aeroplane. 2. A person in the armed forces who has taken part in war and has been missing for 4 years. 3. A person who has been in danger of death under other circumstances and his existence has not been known for 4 years. Article 392. If the absentee appears or without appearing his existence is proved, he shall recover his property in the condition in which it may be found, in the price of any property that may have been alienated or the property acquired therewith, but he cannot claim either fruits or rents. Chapter 5. Effect of absence upon the contingent rights of the absentee. Article 393. Whoever claims a right pertaining to a person whose existence is not recognized must prove that he was living at the time his existence was necessary in order to acquire such said right. Article 394. Without prejudice to the provisions of the preceding article, upon the opening of the succession to which an absentee is called, his share shall accrue to his co-heirs, unless he has heirs, assigns, and representative. They shall all, as the case may be, make an inventory of the property. Article 395. The provisions of the preceding article are understood to be without prejudice to the action of petition for inheritance and or other rights which are vested in the absentee, his representative, or successors in interest. These rights shall not be extinguished save by the lapse of time fixed for prescription. In the record that is made in the registry of the real estate which accrues to the co-heirs, the circumstance of its being subject to the provision of this article shall be stated. Article 396. Those who may have entered upon the inheritance shall appropriate the fruits received in good faith, so long as the absentee does not appear, or while his representative or successors in interest do not bring to the proper action. Title 16, the Civil Register. Article 407, Acts, Events, and Judicial Decrees concerning the civil status of persons shall be recorded in the Civil Register. Article 408, the following shall be entered in the Civil Register: 1. Births, 2. Marriages, 3. Deaths, 4. Legal separation, 5. Annulment of marriage, 6. Judgment declaring marriage void from the beginning, 7. Legitimation, 8. Adoptions, 9. Acknowledgement of natural children, 10. Naturalization, 11. Loss, 12. Recovery of citizenship, 13. Civil interdiction, 14. Judicial determination of filiation, 15. Voluntary emancipation of minors, and 16. Changes of names. Article 409. In cases of legal separation, adoption, naturalization, and other judicial orders mentioned in preceding article, it shall be the duty of the clerk of court which issued the decree to ascertain whether the same has been registered, and if this has not been done, to send a copy of said decree to the civil registry of the city or municipality where the court is functioning. Article 410. The books making up the civil register and all documents relating thereto shall be considered public documents and shall be prima facie evidence of the facts therein contained. Article 411. Every civil registrar shall be civilly responsible for any unauthorized alteration made in any civil register to any person suffering damage thereby. However, the civil registrar may exempt himself from such liability if he proves that he has taken every reasonable precaution to prevent the unlawful alteration. Article 412. No entry in civil registry register shall be changed or corrected without a judicial order, it is amended by the article by the RA number 9048. Article 413, all other matters pertaining to the registration of civil status shall be governed by special laws.